Most people who follow college sports on the West Coast are familiar with Pepperdine University's athletic teams known as the Waves. Netflix created and is now airing a comedy series called Running Point, inspired by Janie Buss, and I hear loosely based on the LA Lakers, that features a professional basketball team that's called the Waves. Well, it seems that Pepperdine wasn't too happy about sharing their name with a fictional, dysfunctional, family run, multi billion dollar sports franchise. Pepperdine University filed a trademark infringement lawsuit and sought a temporary restraining order seeking to block the show's release just days before it was set to premiere. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and today I'm joined by my partner, Jessica Corpuz. We're going to talk about this case and how the Supreme Court's Jack Daniels' decision is reshaping trademark law in the entertainment space on today's installment of The Briefing. Jessica, welcome to The Briefing. First time. Glad to have you here.
Thanks so much, Scott, for having me. I've been wanting to do this for a while.
I'm glad we were finally able to have my people call your people and book you. Well, you're a busy person, you're the head of our firm's litigation department, so I can understand, your time is important. And with that, why don't we kind of get into it? So let's start with the basic facts here. Why don't you tell us a little bit about what this dispute was about?
Sure. So this case involves Pepperdine University, whose athletic teams have been known as the Waves since the university's founding in 1937. Pepperdine discovered that Netflix and Warner Brothers created a television series called Running Point, featuring a fictional basketball team called the Los Angeles Waves. Pepperdine filed for a temporary restraining order to prevent the release of the series, claiming trademark infringement and false designation of origin under the Lanham Act.
So a TRO, I'm not a litigator, but I do know that a TRO is quite an extreme measure. Why don't you tell us a little bit about what a TRO is, what it does, and like the burden of proof that a plaintiff moving for a TRO has to establish?
TROs are absolutely an extreme measure. They're very, very difficult to obtain. In order to get one, you basically have the judge pre-decide the case and says that you are likely to succeed on the merits of this case. And not only that, if the relief you're seeking isn't granted, there is going to be irreparable harm, which means that it's not something that can be compensated in just money damages. It's something that is going to permanently and severely harm your client, your party, whatever it is. So judges do not like to grant them. And in this case, what they're asking for is to prevent the release of a TV series, to prevent it from even going out to the public. So what they're asking for is a pretty extreme restriction on First Amendment rights here, which courts are always, always sort of suspicious of when you ask for them. So it's a very, very difficult measure.
Okay. And I think that played out with the court's decision in the end, which we'll get to.
Yeah.
We'll get to shortly. So, according to the court documents, Running Point, it's an original comedic television series. It's created by Mindy Kaling from The Office and Warner Brothers. It's for Netflix. And as I said in the opening, it's about a very dysfunctional family, loosely based on Janie Buss, who owns and manages a high-profile, multi-billion-dollar basketball franchise. Inspired by the Los Angeles Lakers, called the Los Angeles Waves.
So help me understand, what are the specific concerns that Pepperdine's raised about the use of the Waves trademark here?
Sure. So Pepperdine claimed several issues. So first, they argued that this fictional Los Angeles Waves team uses the word waves with a striking similar font to Pepperdine's registered marks. They also contend that the colors used by the fictional teams were similar to Pepperdine's and that both marks were used in athletic context. So Pepperdine also pointed out that an image in the Running Point trailer includes a framed jersey with the number 37, which they believe references Pepperdine's founding year of 1937. I don't know. I think that's a stretch, but we'll see. Pepperdine, and perhaps the most importantly, Pepperdine was concerned about reputational harm. They argued that the themes in Running Point, including excessive alcohol and substance use, sexual innuendos, and imagery, foul language, and other adult context, don't align with Pepperdine's Christian values and would negatively impact the university's reputation.
So we know that the court denied Pepperdine's motion. We know that the judge found that Pepperdine was unlikely to succeed on the merits of its trademark claims, which is a fundamental requirement for obtaining a temporary restraining order. And we know that the court's denial was based on the Rogers test. Can you
Right.
tell us a little bit more about that?
Yeah, sure. So the Rogers test, for those of you who follow this podcast, we talk about the Rogers test a lot. The Rogers test comes from a 1989 Second Circuit case called Rogers versus Grimaldi. It essentially created a special framework for analyzing trademark claims when they involve expressive works protected by the First Amendment. Under the traditional Rogers test, the Lanham Act doesn't apply to an expressive work's use of a trademark unless that use has no artistic relevance to the underlying work or explicitly misleads consumers about the source or content of the work.
Now, the Rogers test went through a very significant change in 2023 when the Supreme Court decided the Jack Daniels Properties versus VIP Products case, which involved a dog toy called Bad Spaniels that parodied a Jack Daniels whiskey bottle. They're actually very cute if you look at them. The court significantly clarified when the Rogers test should apply. The key distinction that the Supreme Court made was that the Rogers test doesn't apply when a mark is used as a source identifier, regardless of whether it's also used to perform some expressive function. So, in other words, a third-party trademark is being used to identify the source of a product to tell consumers who made it, then the Rogers test doesn't apply, and a traditional trademark infringement analysis should be used. But if the third-party trademark is being used as part of an expressive work and not to identify who made that work, then the Rogers test should apply.
Said well, very, very depthly summarized there. The court found that the Rogers test did apply in this case because Warner Brothers and Netflix was not using waves as a source identifier for their series. In other words, they weren't using it as part of the title of the series. The series is called Running Point, not Waves. And the title card clearly shows that Netflix, Warner Brothers, and Mindy Kaling are the source of the series. The Waves mark is simply used within the context of the series as the name of the fictional basketball team. It's part of the creative expression. It's not a designation of who made the show.
Right. And once the court determined that the Rogers test applied, the court asked whether or not the use of the Waves mark had any artistic relevance to the work. And then secondly, they asked whether the use explicitly misleads consumers about the source of the content.
Right, that's right. And for the first prong, the court noted that the Ninth Circuit has set a very low bar for artistic relevance. The artistic relevance really just needs to exceed zero. The defendants explained that they chose the name The Waves as a nod to the Lakers, whose name alludes to a body of water, and to evoke the Southern California vibe associated with beaches and surfing. The court found this explanation sufficient to establish artistic relevance.
Yeah, and for the second prong, the court found no evidence that the use of the term waves explicitly misled consumers about who made the series. The show is clearly presented as a Netflix, Warner Brothers production. There's no suggestion that Pepperdine was somehow involved. And so, since both prongs of the Rogers test really favored the defendants here, the court, I think, properly concluded that the Lanham Act doesn't apply and Pepperdine couldn't succeed on its trademark claims. And so the court denied the TRO.
Okay, let's talk about how this case might have turned out differently if Netflix had included Waves in the title of the series rather than just featuring it within the show.
Yeah, I think that's a really good question. If the series had been titled something like Waves or the LA Waves, something like that, instead of Running Point, I think the court's analysis would have been very different here.
Right, right. I agree. I think it would have been very, very different. I think it's highly likely that if Netflix had used Waves in the title, the court would have found, I know they would have found that Rogers would not apply. Now, the court in this case specifically noted that quote, the defendants also do not use the Waves mark in their series title, thus suggesting that it was a significant factor in their decision. Now, it's not clear whether the court would have found likelihood of confusion, but certainly I think Netflix would have been still litigating this case.
Absolutely. The court cited to this Mar Vista Entertainment LLC versus THQ Nordic AB case. In that case, Nordic owned the rights to the Alone in the Dark video game franchise. And in October of 2022, Mar Vista Entertainment released its own horror film titled Alone in the Dark. And of course, Nordic sued for trademark infringement. In that case, Mar Vista moved to dismiss the case primarily based on the Rogers test.
Right. And the court rejected Mar Vista's motion based on the allegations in Nordic's complaint. Now, it's important to point out this was a motion to dismiss. So the court decides it based on the pleadings. And so, based on the allegations in Nordic's complaint, allegations that Mar Vista's use of Alone in the Dark as the title of the film was use as a trademark, the court found that Rogers was not applicable. Although Mar Vista claimed that its use was not trademark use, because this was a motion to dismiss, the court was required to accept all well-pleaded allegations as true, including the allegation that Mar Vista was using Alone in the Dark as a source identifier. So I think based on that case, based on Mar Vista versus Nordic, the court may have found if Netflix used the waves in the title, uh, they would have found that Rogers didn't apply.
Absolutely. I think if the series had been titled Waves or something like that, it would have made a big difference, especially at the TRO stage, to preserve the status quo while the rest of the case was pending.
Absolutely. The placement and context of how a trademark is used in an expressive work is really critical after Jack Daniels. Using a mark within the context of a show or a movie as part of the artistic expression, like naming a fictional basketball team, is much more likely to receive First Amendment protection than using that same mark in the title or marketing materials, where it could be perceived as identifying the source of the work itself.
Absolutely. I agree completely. But what do you think of this issue about Pepperdine's concerns regarding potential reputational harm from the association with some arguably questionable content that doesn't align with their purported values?
Yeah, that's an interesting aspect of this case. Pepperdine, as a Christian university, was understandably concerned about being associated with content featuring substance abuse, sexual content, and language that conflicts with their values. However, the court didn't directly address this reputational harm argument in its Rogers analysis. The focus was solely on whether the use of the mark was artistically relevant and not explicitly misleading about the source. Now, this highlights the limitations of trademark law. It's primarily concerned with consumer confusion about source, sponsorship or approval, not with every type of harm that might result from uses of a mark. Other legal theories might better address reputational harm concerns, but Pepperdine focused its motion on trademark infringement.
Yeah, absolutely. So, what lessons do you think that trademark owners should take from this case to protect themselves moving forward?
Yeah, that's a great question. So there are several key takeaways. First, after Jack Daniels, the distinction between using a mark as a source identifier versus using it expressively is crucial. Courts will protect expressive uses that don't mislead consumers about who made the work and are not used as a source identifier. Second, trademark owners should realize that they have less protection against the use of their marks within creative content than they do against uses in titles, marketing, or merchandise. And finally, when seeking emergency relief like TRO, you need to make, and you tell me if I'm wrong here, but you need to make a strong showing on all of the factors, including likelihood of success on the merits. The court didn't even need to address irreparable harm, balance of equities, or public interest because Pepperdine couldn't clear the first hurdle.
Yeah, that's absolutely true. The standards are so high on a temporary restraining order. And especially, like I said earlier, here, where you're asking to restrain a series from actually entering the marketplace, the court is going to really strictly scrutinize all of those elements. And here, court didn't even need to address those other elements because the first ones failed.
Right.
But before we end today, any final thoughts on the implications of this case and the Jack Daniels decision for trademark law and entertainment specifically?
Yeah, that's a great question. So I think this case is a perfect example of how courts are applying the Jack Daniels framework. The Supreme Court didn't eliminate the Rogers test, but they did clarify when it applies. And if you're using someone's trademark to tell consumers who made your product, Rogers doesn't protect you. But if you're using the mark expressively within the content and not as a source identifier, Rogers is likely still applicable. For content creators, this means you have considerable freedom to include trademarks within your creative works as long as you're not suggesting the trademark owner is the source of your work. And obviously, as long as you're not engaging in trade libel. For trademark owners, this means accepting that not every unauthorized use of your mark is actionable. The court's decision allowed Running Point to stream as scheduled on February 27, 2025, giving Warner Brothers and Netflix a significant win, while Pepperdine will have to decide whether to pursue a preliminary injunction or other remedies as the case proceeds.
Well, Scott, this is a really interesting case because now we got to see the court at work interpreting a situation where there is an expressive work here, a TV show, that is using what might seem like a trademarked name in some context. But because they're not using it as the title of their work, they're using it in the context of the expressive work. And so the court got to use the Rogers test here. In other
Right.
cases, it may not be so clear.
Right. No, exactly. And I got to say, I mean, we, as attorneys that represent studios that make shows like this, we deal with this analysis all the time when we're trying to clear titles. And
Mhm.
the Jack Daniels case has required us to investigate titles more deeply, and because especially if it's a title of a series, you're not applying the Rogers test. You're applying some traditional trademark infringement tests like this, like the Sleecraft factors. So you don't have as much latitude because the use of a title in connection with a series is trademark use. It's a source identifier use. So it's a different analysis now than it was before. Use of a third party brand within the show, for the purpose of creating a reality and some other like storyline based purpose. That's when you look at the Rogers test. But as far as show titles, it's the Rogers test is not applicable at all anymore.
Yeah, absolutely. Creatives are going to have to be really careful with their titles going forward based on this ruling and obviously the Rogers test, but they can have a little bit more latitude with the terms that they use inside their work. So, but they're going to have to be very careful about the titles.
Right. Absolutely. Absolutely.
Mhm.
Well, thanks for joining us today, Jessica. Hopefully you enjoyed your first time appearance on the briefing. And you busy litigator you are, we're gonna have to try to book you again soon.
That sounds great. Thank you so much, Scott.
Thank you for listening to this episode of the briefing, and thanks to Jessica for joining me today. We hope you enjoyed this episode. If you did, please remember to subscribe, leave us a review, and share this episode with your friends and colleagues. And if you have any questions about the topics we covered today, please leave us a comment.